Okay, Assalamualaikum. My name is Shahrul Iqbal Marwan Cebba with the metric number 066328. This is family law, and today I am going to explain about the requirements of marriage. So the first requirement is age. Under Section 10 of the Law Reform Act, Marriage and Divorces, the minimum age to marry between both parties is 18 years old. However, exceptional age may be granted to female parties by the Chief Minister. If he is satisfied, he can grant the minimum age to be 16 years old. Next is consent. So there are two types of consent which is required. First one is the consent of parents. So under Section 12, for parties under 21 years old, they must obtain written consent from either their parents or adoptive parents or guardian. However, in the case of Kanagalingam versus Kanagaraja, the parties involved was 18 years old, so there was an issue of whether or not the marriage between the 18 years old was valid. So the court held that they also must evaluate intelligence and maturity alongside their age. If it is impossible to attain consent from the parties involved in Section 12, which is the parents or adoptive parents or guardian. Next is the consent of parties under Section 37. To compel or prevent a person from marrying or entering into a marriage is an offence. Factors that may induce a person to enter into a marriage includes duress or undue influence. Next is consanguinity and affinity. So a person is prohibited to marry between his immediate family, such as mother or grandmother or uncles, and also they are prohibited to marry their in-laws. So under Section 11, 1 till 5, there lists down the types of people that are prohibited to marry. Okay. Under Section 11(6), Chief Minister may authorize any marriage unobjectionable under law, religion, custom, or usage. So here's a disclaimer. The marriage is considered void if it failed to fulfill the age, consent, or the marriage is between parties of prohibited relationship. It is, however, voidable if the marriage failed to fulfill the consent of parties. Okay. So next is the requirements is there cannot be a prior subsisting marriage. For non-Muslim, under Section 5, marriages are considered monogamous. And for non-Muslims who committed the offense of bigamy, which is marrying another person simultaneously in one marriage, under Section 7(1) is an offense. Next, we'll look at the solemnization of marriage. So there are 4 types of solemnization which is allowed under the LRA, which is marriage by certificate, marriage by license, marriage through religious ceremony, and marriage abroad. And lastly, we'll look at the procedures and formalities or registration. So under Section 27, marriages in Malaysia or by Malaysians abroad must be registered. And under Section 31, marriages must be registered at the nearest registrar. So what if there are unregistered customary marriages? So under Section 34, the lack of registration per se does not render a marriage to be valid. So we'll look at the case where such marriage are considered valid and the other are considered void. So the case of Leong Wei Shin versus Chai Siu Yin. So the court held that just because the marriage was not registered at the registrar, however, since they have underwent a Chinese ceremony which is sufficient to determine that the marriage is valid. However, it was considered void in the case of Yo versus Chu, since uh, the marriage was solemnized under a tea party, which is not sufficient to determine the validity of the marriage and was not recognized under Chinese custom to be a valid marriage solemnization event. Okay, that's it from me. So there are 6 requirements of marriage, and each of these requirements must be fulfilled in order for the marriage to be valid. Thank you.